Hi, I'm Lisa Hostetler-Brown. Thanks for joining me for Legally Speaking with LawyerLisa. Today we're going to talk about some triggers that might make you update your estate plan. So we're going to give you 5 tips for events that might happen in your life that might make you revisit what you decided for your estate planning. Now, these are bigger life events, so it should be obvious, but it's not to everybody. So let's go through them. The first one is death. The second one is divorce. The third, dependence. The fourth, diagnosis. And the fifth, displacement. So let's go through them. So the first one that should be a trigger for you is death. Obviously, if you have a spouse or children or parents or anyone you've named in your estate planning documents pass away, it's usually a good time to revisit whether or not you need to update your estate planning documents. I've got a lot of stories that I could tell you about family members who passed away and estate planning documents were never updated, and then there's no beneficiaries, there's no agents, and it goes through the entire court process that they intended to avoid. So if you can take this time, if you have an event like that, to revisit it, it's really good to get that done proactively. The second one is divorce. Well, it seems obvious if you get divorced, but you do need to update your estate planning documents. This is also true if you have other close family members who get divorced. If you've named people as your agents to, let's say, handle finances for you. What if you had a married couple and now they're divorced? That's not going to be good. So it's important to make sure you're keeping an eye on things. And really, not even divorce, but separation would probably make me think twice about naming people. Same thing with children, guardianship. So if you have minor children, you've named a couple to take care of your children and they're not really getting along, maybe we could find somebody else for now. You can always update these documents down the road, but it's important to make sure that they're the right people at the right time so that if you do need them, you have the right agents in place to be able to assist you or take care of your family if you're gone. The third one is dependence. So this ties into the last, but if you have children under the age of 18, or you are the court-appointed guardian for somebody of any age, it's a good idea to include a provision in your will that says who should be the guardian for them in the event that something happens to you. Now, your spouse, if it's the father or mother of those children, would have next priority, or if you're not married to them, their parent would have next priority. But after that, if something happened to both of you, who would you nominate to be the guardian for those children? And again, if you have a special needs child, this would extend to any age. You want to put your preferences in writing so that down the road, in the unfortunate event that something does happen to you when you have these children that need your care, that the court knows what your wishes are. And they're more apt to be able to follow them if you put them in writing legally. So always keep in mind, guardians are very important if you have any children of any age, if they need it. Next, diagnosis. A diagnosis can be a difficult time for everyone. A cancer diagnosis, a dementia diagnosis, Alzheimer's, a sudden stroke, anything that comes up where it changes what the future might look like is important time to reevaluate what you have. Now, if you have something that's slow or progressive, you can get your documents put in place post-diagnosis. It's not too late. As long as your loved one still can understand what it is that they're signing, they'll be able to sign new legal documents. But if you wait too long, they'll no longer be able to sign documents because they don't understand them. Whether somebody can sign documents is not about whether they can hold a pen in their hand. It's about whether they have the mental capacity to understand either a power of attorney or a testamentary document, such as a will or a trust. So don't wait. If there's a diagnosis, it's important to see an elder law attorney so you can get a plan in place. And I'd tell you, it goes well beyond just getting the legal documents updated. You really need to have a plan in place for how you're going to approach this. So don't wait. That's an important one of these. And then the last one is displacement. We're talking about moving or being in a new location. So if you've moved from out of state, you should have your documents looked at again. Does it mean they need to change? Not necessarily. Are they still valid here? Maybe. You should definitely get an opinion on that. So go to an experienced attorney, have your documents reviewed, and make sure that they'll work in the state that you're in. Now, for people that have done trust planning, you have a much higher likelihood that they're going to be just fine. But it's important to have it checked. And if it's been a while since they've been done, that could be another trigger. I'll tell you, there's been a lot of law changes here recently. You've probably seen it on TV. If you're watching the news, you know that. Those law changes can impact how your documents work. And so if it's been a while since you've had your documents done, it's time to get them reviewed. So hopefully these tips will help you. You can check out on the QR code more information on our website. We'd love to help you with this. I'm Lisa Hostetler Brown. Thanks for joining me for Legally Speaking with Lawyer Lisa.